Thank you, Mr. Chairman. It's a pleasure to take a call on this part of this very important piece of legislation, the Inquiries Bill, and really to continue from where the last speaker, Holly Walker, left off, which was to note the distinction between what we have now, where there are we have a law relating to commissions of inquiry, that inquiries appointed under the authority of the Governor-General, and the existing situation with ministerial inquiries that don't have the same status or standing or certainly gravitas perhaps as commissions of inquiry under the Commissions of Inquiry Act. This bill and Clause 3 of the bill in particular and the subsection 3 of Clause 3 repeals Section 2 of the Commissions of Inquiry Act, which confirms that commissions of inquiry under that Act convened under the auspices of the Governor-General. This bill, once enacted, will give a similar status to ministerial inquiries as currently apply to commissions of inquiry. And as Holly Walker has noted, that is a big step. But, sir, I would say that is a good step because in addition to the many other enactments that provide for various inquiries, standing commissions of inquiry such as the Independent Police Conduct Authority and acts that allow inquiries to be established. This allows, released in relation to those matters of public interest, important public interest that arise from time to time, where a minister, and falls well under a minister's bailiwick, then the minister can act with some haste to establish an inquiry that has some authority that can get to the bottom of it. There's no question that as the complexity of government administration grows, mistakes do happen, misjudgments happen, catastrophes happen. And the public needs to know that if those sorts of circumstances arise, then we have the means and the machinery to ensure that an appropriate inquiry can be established, the causes of a particular incident or event can be established, and the public confidence can be restored. So that change in subsection 3 or clause 3 of clause 3 and the repeal of section 2 of the Commissions of Inquiry Act 1908 is a very important one. I might say that it's quite coincidental that the government today introduced new legislation for incorporated societies, and the Incorporated Societies Act is also another piece of 1908 legislation that has stood the test of time. There aren't many pieces of 1908 legislation that remain on the statute books. The Trade Unions Act is another one. And these are very important pieces of legislation that have stood the test of time, more than 100 years, and yet here we are repealing these important provisions. But I think that reflects, as I think Louise Upston understands and agrees with me, that after more than 100 years, circumstances change, and it is important to consider modernity and what we need to do to modernise these pieces of legislation. So the other point I wanted to comment on was in Clause 4, the interpretation section, and the definition given to core participant, which actually appears in Section 18, which is Part 3 of the Act, but it's there referred to by reference. I just want to make this point, is that I think that is a worthwhile development, to give an inquiry that is set up under the aegis of this legislation, once it is passed, to allow the inquiry, ministerial inquiry included, to establish who are the critical people they need to talk to so that they are given an immediate standing in terms of participation in the inquiry. And I think that will enable inquiries, once they are called and set up, to get underway very quickly and to get the people who need to be involved quickly involved as well. If there are other participants, other people who consider that they ought to be called upon, of course they can register their interest, and the person who is called upon to conduct the inquiry can very quickly make a judgment about whether those other people, perhaps slightly more peripheral, should be called upon. But in the meantime, it is good that we have core participants identified and who can be called upon to make submissions and to give evidence in an inquiry. And of course that goes along with the power that will be that is provided for in this bill, set out in Clause 3, the new power to compel people to participate in an inquiry as required. And that would also obviously include core participants. So these are good and important measures when it comes to restoring public confidence in the government.
The Honourable Ruth Dyson.
Mr Chairman, thank you very much for the opportunity to speak.